Hello, I am just going to wait here for a second. We're starting just a couple of minutes late here, but I want to give people a chance to join in to see the live stream if they wanted to learn more about this topic. Just to kind of give an overview right now, my name is attorney Stacy Schlemmer. I'm a family law attorney practicing at Peterson, Berk Cross, located in Green Bay and Appleton, Wisconsin. Today's topic is tips for placement orders, the do's and don'ts for placement. So this is primarily tailored to individuals who have family law matters, whether it's a paternity or divorce case, whether it's potential modification moving forward, to give you some information that might be useful to you for placement orders moving forward. Just a formal disclaimer, this does not create an attorney-client relationship. There is no attorney-client privilege between anyone watching this live video, whether it's as it's being recorded now live or if you're watching it at a later time. In order to set up a consultation, just give my office a call and we can get you on my calendar, and then we can talk more about specifics and go from there. But I just want to make sure that everybody is on the same page, that this video does not in any way create an attorney-client relationship between myself and anyone watching this video. So I see that there are a few people who are watching now, so I'm going to get started and get into a little bit more of the meat of this presentation. I know that this is Lunch with a Lawyer, and I know that Attorney Shanley, who does these quite often, usually has a sponsor for lunch and has his lunch to show everyone. I have been crazy busy this week, a lot of new clients, so I do not have a lunch to show or share with everyone. I did not have time to line up a lunch sponsor, so I apologize that that part is lacking in my presentation here. But getting into the do's and don'ts for placement orders, really, my first do would be to be specific in your placement orders. Make sure that you have a specific placement schedule if that's appropriate for your case, which is going to be appropriate in most cases. And when I say have a specific placement schedule, I mean have set dates and times for placement exchanges. If you need to, have set locations for placement exchanges, and say who is going to be facilitating those placement exchanges. For example, if it's going to be a schedule where mom has primary placement and dad has every other weekend, clarify what you mean by every other weekend. Does that mean Friday after school or 3 p.m. until Monday morning drop off at school or 8 a.m.? Does it mean Saturday and Sunday? Does it include overnights? What times are we talking about? Be careful that you don't simply say every other weekend, or mom has Monday, Tuesday, dad has Wednesday, Thursday, and the parties alternate weekends. That's not specific. A court would not necessarily know what that means. The parties might not even necessarily know what that means unless it's specified in the order. So if you mean by mom having every Monday, Tuesday, that that's from 8 a.m. Monday until drop off at school Wednesday morning, put that in the order. If you want to have language that says it's always pick up and drop off at school, however that lands, make sure you have language that says what happens if there's not school that day. Does that mean 8 o'clock? Does that mean 9 o'clock? Does that mean that the other parent, that you keep the kid until the school would have been over at 3 p.m. that next day? Make sure that you clarify that, because the court's going to want to see that if there's ever an issue with if there's alleged contempt by one parent not following the court order. So that'll save you a lot of headaches down the road. If you want to specify, that the placement parent drops off with the other parent to start the other parent's placement time, that can help alleviate potential arguments or disputes in the future. And again, if you say where the exchanges happen, if it's not going to be at school or daycare, maybe you want to specify that it's just going to be, the placement parent drops off at the other placement parent's home to start placement, or the parties will meet at the Sheriff's Department safe exchange. Those are just examples of different words, different clarification that you can have in an order that might help you down the road. One of the don'ts that I would tell you to avoid is with being vague. So that ties right in with the being specific. You want to be specific, don't be vague. Avoid leaving things open to interpretation or discussion if you can avoid it. So along with the examples that I gave you with trying to be specific in orders, things you want to avoid are saying that it's just going to be, we can agree on vacation placement and holiday language without putting anything in the order, and we'll just talk about it as it comes up. That might work now, but things change, things happen, and what happens if you don't have anything in an order setting out, for example, Christmas Day placement, and you think you're able to reach an agreement, so you don't put anything in order, and then Christmas Day comes along, and lo and behold, say it's the mom in the case. Mom gets jealous because dad started dating a new person, and mom says, I'm not sending the kid for Christmas, I don't care if we said we were going to talk about it, I'm not talking about it anymore. And then the dad in that situation would miss out on Christmas placement. The easier situation or circumstance that you could do in your order would be to simply include language that says the parties will agree to discuss these issues, but in the event that they cannot agree, this is what happens. So the example I just gave was with the holiday schedule. Okay, so have language that says the parties agree to discuss holidays as they come up. However, in the event that the parties cannot agree, this is the schedule that they'll follow. There's no harm done by this. It still promotes the parents talking to each other and trying to work out agreements for holidays, but it has something there in case, for whatever reason, the parents can't agree to something, so that somebody doesn't lose out on holiday placement in that example. That also would apply to a regular placement schedule. That would also apply to potentially vacation language. So even if the parents want to try to work out things as they go, that's great, that's fine. The goal is that the parents never have to look back at their court order. They can just reach agreements and move forward, talking to each other and communicating. Great. The reason you have the language specified in the court order is in the event that something happens that prevents the parties from reaching an agreement. So that's something that I would suggest you avoid, is being vague and open-ended. So I talked about a little bit the holiday and vacation language. That goes to my next do. One of the things you want to do in any placement order is have a set holiday placement schedule as well as vacation placement language. I see it often where, especially parents with really young kids, even infants, don't think they need to have that in an order because they're not really worried about it yet, or they think they can talk about things, which is great. But again, you want to have that language in there because at some point between birth and age 18, you're probably going to want to have set placement for holidays to share between both parents, and you're probably going to want to take the child on a vacation at some point during the child's 18 years, that they're a minor child under your care. So with a holiday schedule, you want to make sure that you have a comprehensive list of any holidays that are going to be considered holidays for purposes of placement. So some parents, for example, will just use the regular calendar with the regular federal holidays and religious holidays. And some parents will include the child's birthday as a holiday. Some parents will include their own birthdays as holidays. It's up to you what you want to do in terms of what's considered a holiday. If you have more non-traditional holidays, you can include those as well. It's up to the parents what they want to include. So if you celebrate, for example, winter solstice or summer solstice, those are not going to be on the standard list of holidays that the court provides in forms, but that's something the parents can absolutely agree would be considered a holiday for purposes of placement. Along with listing the separate holidays that would be included and exercised between the parents, you would also want to have specific start and end times. So you can say that the holidays are just the day of the holiday, and you can specify a start and end time. For example, 9 a.m. to 9 p.m. would be a holiday. You could agree that the holiday runs the day of the holiday until the next morning, so 9 a.m. the day of the holiday until 9 a.m. the day after. You also want to make sure that you clarify if a holiday is just the day of or if it's a weekend. For example, a lot of people miss that when they say Memorial Day and Labor Day in a holiday schedule, if you don't specify that it's the weekend, it's just the day of. And a lot of people mean to have that incorporate the whole weekend, but they don't specify it, so then you're stuck. So just be sure that if you do want something such as Memorial Day weekend and Labor Day weekend, you need to clarify that that goes from, whatever, whether it's Friday at 8 a.m. until Tuesday morning at 8 a.m. or however you want to designate it. You want to have that specified as the length of the actual holiday. A lot of people will just say that whoever has Memorial Day, the opposite person would have Labor Day for the weekend, so that each parent has a long weekend. If you want to specify that one parent always has Memorial Day and one parent always has Labor Day, that's fine too. Sometimes that's a little easier for planning purposes, so you know years in advance when you're going to have that specific weekend. But that's up to whatever the parents want to agree for holidays. As for vacations, I would encourage you to think about what you want to do in terms of requesting notice. Do you want to state in the order that you are requiring 30 days notice from the other parent? Do you want to require 6 months notice? Do you want to have a specific deadline every year that a parent has to have their dates for vacation placement given to the other parent? That's up to you. Most commonly, I find that 30 days notice is put into orders because that gives people enough of a heads up without requiring parents to maybe look a year in advance to try to plan out vacation when you might not know what is going to come up in the meantime, and you may need to change those dates. So you should think about putting in some sort of a deadline for how much notice one of the parents has to give to the other for planned vacations with the kids. You want to think about how you want to share information and how much information should be shared. So typically parents will want to have some sort of language in their order that says that the vacationing parent needs to provide information to the non-vacationing parent of the location where the kids will be staying, an emergency phone number, which usually means a non-cell phone number that the parties can communicate if there's an emergency, and exchange flight information or train information so that again, in the event of an emergency, the non-vacationing parent can find the kids if need be, and the other parent if there's an emergency and the other parent needs to be contacted. So those are things to consider putting in an order for vacations. The other thing with vacations, and this is in my don'ts list, is don't put too many limitations or restrictions on vacation language. And what I mean by that is make sure that you're okay with what you're requesting that the other parent have to do, because it's likely going to go both ways. That if you're saying the other parent can't go out of the state without notifying you and getting your permission, you better be prepared to have to do the same thing with the other parent. And that may change how you feel about pushing forward with requests. So a lot of people will come to me and say that they want to have something in the order that says the other parent can't take the child out of state. Okay, theoretically, I understand why someone may want to have that as part of an order. However, what does that mean? Does that mean anytime the kid crosses state lines for any amount of time? Does that mean just for vacations? Does that just mean for an overnight? What does that actually mean? Because if you think about it, do you really want to have to notify the other parent or get the other parent's permission to take the kids up to Menominee, Michigan, right across the border, or to Six Flags outside of Chicago for the day? Do you want to have the other parent's permission to take the kids to Mall of America, again, right across the state lines? technically, if you want an order that says neither party can take the kids out of state without the other parent's permission, the other parent could deny a request to go to Six Flags for a day or up to the UP for a day, which usually in hindsight seems a little silly. So just consider that when you are making certain requests of the other parent, to see if you really actually want to do that and be required to be under the same limitations. Also with language about travel and vacation, think about how much control you want the other parent to have. If you're wanting, say you do want language that anytime the kids go out of state, say it's for any overnight or longer, that you need to give prior notice to the other parent. That's fine, but just keep in mind how much notice is going to be required. Does the other parent have the ability to deny your request? What other information are you going to be exchanging, such as where the kids are going to be staying, what the itinerary is, things like that. Maybe you don't want to require that because you don't want to have to provide all of those details to the other parent. And it's really a matter of trust and how much you trust the other parent. Now, keep in mind, travel outside of the state is allowed by law. It's simply moving out of state that a parent can't do if both parents are awarded some sort of placement and there isn't a court order saying that the parent can move the child out of state, okay? So I don't want people to be concerned that they have to have language requiring permission to leave the state just for a day trip or for a vacation because they're concerned that they're going to forfeit placement or the parent's going to move. That's different. That's a completely different statute, and I don't want people to be too overwhelmed or think that that's a waiver of placement time or something like that. It's not. Another do that I suggest is anticipate future possible problems that could come up or future issues and address in your order if possible. So I know that, if you're dealing with a newborn, you're not going to be able to anticipate all of the issues that are going to come up in that child's life or that could come up between the parents over the next 18 years. That's impossible. Nobody knows what's going to happen in the next 18 years. However, there are certain things that you can anticipate and try to reduce potential for conflict moving forward. So certain things that you might want to consider that are going to happen in the future, say you're dealing with an infant or a very young child, think about school enrollment. When is the child going to start school? Is the child going to do 3K? Is the child going to do 4K? Where is the child going to attend school? Is the school going to be public or private? Do you have an agreement on what school district the child would attend? Those are things that you probably want to discuss sooner rather than later so that you're not stuck right up to the wire when the kid's supposed to be going into 3K or 4K, and all of a sudden you're talking with the other parent and realize that you don't have an agreement on where the kid goes to school or whether the kid should be in 3K or 4K. Because then what you have to do is you have to file a motion with the court and you have to have the court weigh in and give you an order on what's going to happen with school for the kid. So that's one example. Another thing that you should be anticipating is activities, events, lessons, things like that for the child as the child gets older. This applies to kids who are 6 months old up to 16, 17, 18 years old. So who is going to be responsible for signing up the kid or kids for activities, for extracurriculars, for lessons, things like that? Who is going to be allowed to sign the kid or kids up for these activities? Does the other parent have a right to deny signing kids up for certain things? Do you want to have limits on whether a parent can sign up the kids for activities or events or lessons on the other parent's placement time? These are things to keep in mind. Some parents I've seen set schedules on they're going to meet either it's quarterly or once a year or before the school year starts, and they sit and plan out what activities the kids are going to be in, when the enrollments have to happen, and who's going to take care of it. that's not a bad idea to have something in place to know what the plan is, so that you don't all of a sudden get in a situation where mom signs the kid up for karate on, every day of the week at 6 o'clock, and that half of that is dad's time, and dad's sitting saying, what the heck, why did you do this? Now you just took away placement time for me, and we never talked about it. It happens a lot, and so a way to avoid that would be to plan out meetings where you talk about what activities the kids are going to get enrolled in and when those are going to actually happen during the week. So say mom wants to sign the kids up for karate. Okay, mom sits down with dad, goes over the different options of where the kids can go to karate, when the different lessons are, and if it happens that some of the lessons are on mom's time, some of the lessons are on dad's time, if the parties agree to that, great. If the parties don't, and dad says, I don't want any of the karate to overlap with my days, I have the kids in piano lessons on my days, then maybe mom needs to go look at a different karate place that would have lessons available only on her days. But you can see how at least scheduling a meeting, you can avoid the other parent or the parents blowing up at each other because nothing was discussed and somebody signed up the kids for something. And you definitely want to avoid a situation where the kids are excited about being signed up for something, and then all of a sudden, that's taken away because the person who signed the kids up didn't talk about it with the other parent, and then the other parent refuses to take the kids, or takes the parent back to court who signed up the kids and said, this is a violation of custody, or it's you're overstepping on my placement time. And then who gets hurt? The kid. If the kid is excited for the activity that they thought they were going to be participating in, and then that gets taken away from them. I like to see situations where parents can talk to each other. Obviously, it's not always possible, especially in domestic violence situations where parents can't, meet at a Perkins or something and talk through all these things. So it's just something to consider, even if it's not sitting down and meeting in person. If you're using some sort of an app such as Our Family Wizard, or you communicate by text about the kids, maybe plan out, okay, every January and every July, we're going to set a date and we're going to talk about what activities we're going to sign the kids up for the next 6 months or for the next school year, something like that. And at least then you're setting a schedule to keep both of you accountable and require a conversation, basically, whether it's in person, by phone, by email, via Our Family Wizard, doesn't matter. It'll just help to make sure that you're on the same page with what's going to happen for the kids moving forward. My final don't is, don't fall into the trap that you agree to something just to get it over with. I hear that all the time, where parents will come to me after they've reached agreements and they'll tell me, oh, I shouldn't have agreed to that, but I just wanted to get things over with. I didn't want to have to pay an attorney. I didn't want to sit and fight in court, so I just agreed to it. The problem with that is, at least with an initial final order for paternity or for a divorce, you're looking at a 2-year waiting period before you can even request modification of an order for custody or placement, unless there's been a substantial change in circumstances and harm to the child, which is very hard to prove. Usually you need to have some sort of physical abuse verification or substantiation from Child Protective Services or something like that. So it's very difficult to get anything changed within the 2-year window. After that 2 years, you still would need to show a substantial change in circumstances and that it's in the child's best interest to modify a placement schedule. So it's still difficult to get a review or change to the placement order even after 2 years. So keep that in mind. I always tell people, if you're uncomfortable with something that's being proposed by the other parent or even by a guardian ad litem at some point, the time to fight it and make your voice heard is before that initial final order. Because once you have that final order in place, it's hard to get that changed. So those are my top 3 do's and don'ts for placement orders. Obviously, there's a lot more on that list, but I only have half an hour to convey these to you. So if anyone has any questions for me, feel free to post them on the comments to the video. I'm hoping they're coming through. Otherwise, I will, I'll try to respond later on if I see any more come through. So right now, let's see if there's anything here. So I don't see any questions as of right now. So if you think of something that you want to run by me, if you have a specific situation that you want to discuss with me, whether it's about placement or any type of family law issue, just feel free to give my office a call. We'll get you scheduled for a free 30-minute initial consultation. The number is 920-831-0300. We also, in addition to family law, at our office, we do have attorneys who specialize in criminal defense, personal injury, and estate planning. We also have a couple of other attorneys who do family law. So if you have any legal issues on those topics, we offer a free 30-minute consultation for any of those areas of law, and we're more than happy to help you. If we can't help you, we'll refer you out to a capable attorney who can help you. So with that, seeing no questions as of right now, I'm going to say goodbye and have a nice rest of your day.